By the way, right, the defense wants to stall this out, I think generally speaking, as long as they possibly can. And they also have an obligation to not conduct a hearing if they're not up to speed on the case. Both indicate that agencies recovered minute quantities of DNA of various items of evidence, which the reports opine consists of a mixture of up to 5 or more individuals. What? Unless the materials here have been produced to him by April 17th, date on which this motion is set for a hearing, the preliminary hearing should be vacated until they have been. And if they have been produced by that time, the hearing needs to be postponed no less than 6 months. The Kirk-Robinson bullet motion. You see this one just dropped in the case of Utah prosecuting Tyler James Robinson, the alleged Charlie Kirk assassin. And this comes from his defense team. There are a bunch of headlines that are flying around on this thing. Things like, oh, it's not his bullet, and so therefore he's not the shooter. And then on the other hand, there's, oh, the parents are going to come out and testify against him, which means he's absolutely the shooter. This is Tyler Robinson's motion to vacate or continue the preliminary hearing. And as we've talked about in this case before, in Utah, it is a preliminary hearing mandatory state. Unless the defendant waives this, then they have to have it. On March 12th, counsel for the parties met and conferred about discovery. And based on the state's representation, the state intends to introduce and present discrete buckets of evidence. We love using buckets as a euphemism through 3 identified law enforcement witnesses. So we've got DNA evidence that's coming in and ballistics reports coming from the FBI and the ATF. We got phone and social media data. We've got testimony from law enforcement officials. And this is a big one that's capturing a lot of attention. Testimony by Mr. Robinson's parents and roommates. This is the defense writing. So in other words, the prosecutors will bring in the parents. We don't know what they're going to testify about. I've seen some headlines. Oh, well, that means like obviously he's guilty because the parents are going to come testify against him. Doesn't even mean that they're cooperating essentially with the prosecutors, and they may be subpoenaed to come in here and testify and be forced to come in and just explain some basic things. Where was Tyler Robinson the day of the shooting? Well, he was here. Okay, perfect. And then did you see him again between these hours, between this time and this time? No, I didn't. Okay, so it's possible that he left. Yeah, it's possible. So stuff like that. Doesn't mean that the parents and the roommate, Lance, the trans lover, are going to come out and implicate the guy. We don't know what they're going to say, just that the prosecutors have intimated that they're on a witness list. Now, the prosecutors are going to bring in a bunch of hearsay. The rules in Utah allow that. They're going to come out with scientific laboratory and forensic reports and other things. They're also going to have non-testifying peace officers and other yet unidentified or even currently unavailable lay witness statements. So people who are not testifying, but they said something and they'll just read that into the record. The state may also present 1 to 3 lay witnesses in this matter. Now, discovery in this case is incomplete. It's voluminous and its processing of it is very complex. Materials from numerous local, state, and federal agencies identified thus far as involved in the case are filtered through the Utah State Bureau of Investigations. And what happens is the SBI will then send the materials to the Utah County Attorney's offices where they are reviewed, Bates numbered, and redacted prior to being reviewed and sent over to the defense. We got this little, flywheel, this process that's happening. One agency sends it to another, then they stamp it and then send it to us. And so due to how these are provided, the defense paralegal must devote a significant amount of their time organizing it before it can be reviewed and even utilized by us. So at this stage in total, the defense has received approximately 20,000 files, excluding digital electronic discovery that we got on a hard drive. Now, of these, we've got documents and image files that have 61,000 pages. Audio files are 31 hours in length, more than 5,000 video files that contain more than 700 hours of video, which I presume contain some evidence of who the guy was walking up and down the stairs and more. The digital electronic discovery that was received on March 12 is 12 terabytes of data, okay, gobs of data, over 600,000 files. The initial review of the digital electronic discovery is anticipated to take 60 days to complete, after which time it can be determined if the downloads are complete or if any additional time is needed. By the way, right, the defense wants to stall this out, I think generally speaking, as long as they possibly can. And they also have an obligation to not conduct a hearing if they're not up to speed on the case. The defense team has devoted, and part of the reason for the delay is to let the public kind of fervor around the case dissipate a little bit. Hopefully everybody moves on to something else else is what they're thinking. And then we can come back and have a fairer trial without everybody who is, hyper focused on this case, because it's a major topic of conversation, obviously. I'm not saying forget about Charlie Kirk or anything. I'm just saying that's kind of the strategy. You want distance between the crime. And we'll continue to devote significant resources to processing these things. However, the defense team is realistic, and the comprehensive review of what is missing is going to take hundreds of hours. And I think that is actually fair. I mean, this is a ton of evidence. Here, there are materials known to the police and prosecution team that have not yet been provided. Doesn't mean they don't have them. And, some of these detailed forensic reports, examinations, some of them can take a very long time. So while it is anticipated that discovery will be ongoing, we want materials that are known to be reasonably available to them. That is, materials known to be in the possession of law enforcement partners. Both the county and Mr. Robinson continue to await a vast amount of information relevant to review by the FBI and the ATF's DNA analysis, including but not limited to validation studies, crucial electronic data files, and a case file for a comparative bullet analysis and bullet lead analysis that is still in progress at the FBI. So that's been about 6 months now, wondering why they're not accelerating in a case like this. It's still in progress. We still don't have a comparative bullet analysis or a lead analysis. So case file protocols, none of that is available even to the county attorney. Okay, so the prosecutors don't even have it. ATF and FBI are still processing it. Now, what we're going to see about the bullet and the fact that they can't actually identify the connection of the bullet back to the gun, which doesn't mean it didn't come from that gun. It just means that it's inconclusive, in other words. They did get that report relatively quickly. And the case file and the protocols for a comparative bullet analysis that was conducted by the ATF. So even the prosecutors don't have it. The feds still have it. Now, identifying what's missing is an amorphous task. We don't know. There's stuff that you know that you don't know or don't have. And then there's stuff that you don't have that you don't know that you need. In addition, there are various other areas of forensic science discovery that are not yet complete and that must be completed so that we can decide whether to proffer any exculpatory evidence relating to those areas of the evidence. So, in other words, we need a continuance. There's too much that we don't have. We're entitled to this. That's a legitimate reason. And the United States Supreme Court has also said, this is a critical stage. This is not some throwaway hearing. Court of Appeals explained the same thing over in this case. And for us to actually do our jobs, counsel must have the evidence. Even the guidelines under the American Bar Association say we have to do a good job, and we can only do that if we have the evidence. Supreme Court has said it. Sixth Amendment entitles a defendant to rights, and so ABA guidelines. Here, we've been doing our best, says the defense. We've been diligent in attempting to fulfill our responsibilities, and this is quality legal representation. And look, in this case, Strickland, those are capital murder charges, and capital cases are different than other criminal cases, and so we can't proceed without the evidence. And the receipt of the discovery is not enough. Just like sending it to us and then holding a hearing is not enough. Very complicated. So we have to actually review it. We have to give it, right? If it takes them 6 months, then our experts also need to be able to do their own review and their own analysis. So you should give us the same time or, multiple additional days or weeks or months as necessary to do our job. They also say our review has just begun, and defense counsel in this case have begun the multi-step process of requesting and reviewing the forensics and the discovery, locating and retaining the experts, providing the experts with the necessary materials, performing an aggressive expert re-examination mandated by the guidelines, consulting with experts. It's all beginning. For instance, back in March, on March 12th, the state indicated that it intended to introduce the autopsy report into evidence. So the Charlie Kirk autopsy report will come into evidence, but they're not going to have any supporting expert testimony. Just drop it in there. The autopsy report was completed on September 16th, was not produced to the defense until November 13th. The autopsy photographs taken on September 10th were also not produced to the defense until March 18th. Rest in peace, just sick. With the report and the photographs, the defense is now in a position to provide an independent pathologist with some of the discovery tools necessary to conduct an independent evaluation of the autopsy. But it is anticipated that they're going to identify additional things that they're going to need. And this happens all the time, right? So a defense expert looks at the initial tranche of evidence and says, well, I need this and I need this. And defense attorneys aren't forensic pathologists. So they ask for certain things. Then the actual expert looks at it and says, I need a bunch more things. Go ask for this, 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 and this, and this. As indicated in the March 25th informal discovery request by the defense, which was made after a complete review of the discovery, even more substantial discovery exists with respect to DNA and ballistic reports that the state says it's going to offer at the hearing without any supporting expert testimony, because hearsay is allowed. It's not a full trial. It's just a preliminary hearing to see if you can bind somebody over. So a lot of this is normal. Now, the summary DNA reports that were produced by the FBI and the ATF both indicate that agencies recovered minute quantities of DNA of various items of evidence. which the reports opine consists of a mixture of up to 5 or more individuals. What? Both agencies employed commercial software called STR-Mix in an attempt to sort out the various contributors to the DNA sample. Regarding the firearm evidence, the defense has been provided with an ATF summary report, which indicates that the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. So they couldn't make a match. Doesn't say it was not the bullet that was in. It just says it's inconclusive, essentially. Could have come from a different gun. Could have come from a different shooter. Or it could have come from that very rifle. So I think the defense will obviously, wait to see what else they get on this, but we've only gotten a summary. Summary says can't identify it. That's not a good fact for the prosecution. They would love the ATF to have a nice chain here. Say ATF, oh yeah, bullet came from the gun came from Tyler Robinson, and Tyler Robinson's DNA matches the trigger, and we can validate it, follow the bouncing ball very easily. We're having some issues with that because now we have bullet that is, questionably connected to the gun. It's unknowable, it's inconclusive, and we got apparently 5 DNAs samples that are all kind of mashed into one. And again, we don't know what these samples are coming from, but it's not as clear cut as the prosecution would want. So although the state has not indicated an intent to produce this report at the hearing, the defense may want to and offer the testimony of the ATF firearm analyst as exculpatory evidence to say, oh, well, you can't show that that came from the gun. And of course, he might come back and have a very good answer to this. ATF analyst might come back and say, well, yeah, it fragmented into 100 pieces. It's all over the place. So we can't put it back together. I think there was a movie where they did that. They got all the various fragments and they put it back together, and then he got a fingerprint off of it from loading like Batman or something. He's like, it's not Batman, okay? So there's a good reason. Doesn't mean that it didn't come from Tyler Robinson's gun. He says, I just can't pin it on that exactly because of all of these explanations. Is that normal? Yeah, it's very normal. It happens all the time. How many times does that happen? Happens every 5th analysis that I do. The bullet fragments, I can't try it. So it might be very explainable. But they say, we only have this summary. We don't have the underlying analysis that he created. And so in order to make this determination, it is necessary for the defense and the firearm expert to review the case file and the protocols relating to his exam. Did you screw something up in the exam? That's why you can't connect it? That has not been provided yet. The state has also indicated that the FBI is in the process of conducting a second comparative bullet analysis, as well as a bullet lead analysis, but that analysis is not complete. And these analyses are, again, until the defense receives the case files and the protocols relating to these and has them independently evaluated by the expert, they will not be in a position to assess the reliability of this if either the state or the defense wants it. So again, it's more unknown. There are also several categories of other incomplete forensic discovery outlined in our request. Until we get the case files and protocols related to these and has them independently evaluated, we are not in a position to assess the reliability of this evidence if either side decides to offer it. Importantly, in a capital case, we have a lot of issues and a lot of things we can challenge. A state cannot avoid this constitutional requirement and shift this to the defense to make it their burden. The requirement that a Utah defendant not be held in prolonged custody until we have this hearing is articulated in this case, and as demonstrated, we're doing everything we can, but we just don't have the evidence that we need. Then we get the next factor. It says he didn't have anything to do with this delay. As described, we're actually working very hard. We've made all the efforts to make sure we're doing everything we can. We verbally communicated. We've communicated in writing. So Tyler Robinson is not the reason for the delay, so grant us a continuance. And 5, finally, if you don't give us a continuance, it's going to hurt him legally. He has a constitutional right to review the evidence before this hearing happens, where the evidence that has not yet been produced is both highly technical and scientific. We need to review it. And so there will be prejudice against him if you do not grant us a continuance, because he'll be able to come back and say you were unprepared and you didn't actually follow the rules before you had this hearing. So none of the 5 factors leave a basis for us to deny the hearing. We should have a continuance. The state's decision to proceed with forensic evidence is its own, but it can't do that without giving us a copy. We need to see it too if they want to use it. So unless the materials here have been produced to him by April 17th, date on which this motion is set for a hearing, the preliminary hearing should be vacated until they have been. And if they have been produced by that time, the hearing needs to be postponed no less than 6 months in order to permit him a meaningful period of time to review. By the way, I think they're right about that. I think that the judge is probably going to grant them that continuance. Like, the judge does not want to rush this. We've already seen that. So they're very on top of their request. Even the county attorney doesn't have a lot of this information, and the judge is not going to want to rush this, I don't think. So it can come back and he can get bitten if they make a claim that he didn't have, his due process not afforded an opportunity to gobble up evidence and present a cohesive defense.